Court calls case number 13-CR-001. The case is styled State of Missouri Plaintiff versus Betty Quick, defendant. The defendant, Ms. Quick, has been charged by way of information that reads as follows. Comes now Christopher Day, the prosecuting attorney of the County of Greene, State of Missouri, being duly sworn and upon information and belief, and states that there is probable cause to believe that the accused committed the following crimes. Count 1. Assault in the second degree.
On the afternoon of October 23rd, 2013, at approximately 3:05 p.m., there was a terrible car accident at 3131 East Kearney Street in Springfield, Missouri, and Greene County. That happened when a silver Ford Crown Victoria slammed into a telephone pole, the results of which were horrific. The passenger in the car, John Ride, was sent to the hospital with head and neck pains that turned out to be a fractured vertebra. The driver was nowhere to be found. What was found, however, was a cell phone, a black iPhone 4S, that was on with a text message displayed indicating that whoever the driver was, their irresponsible actions led to a serious crash that seriously injured another person.
Where was the car crashed into exactly? Like, where was the damage done to the car?
On the driver's side door, in the windshield.
Okay, and then you said the phone was found where on the floorboard?
On the right side.
So on the passenger side.
No, on the right side of the driver's side.
Everyone has the right to live out their lives without the fear of injury from another's actions. When that truth is broken by members of our society, we expect swift and fair justice to be delivered unto the perpetrators. We must continue to enforce the notion that reckless and irresponsible actions carry heavy consequences. Those that ignore this truth must be punished in the hope that neither they nor others will continue to act without regard for another person's life. The defendant, Betty Quick, must be punished for her dangerous actions that resulted in serious bodily harm to another person. The charge of assault in the second degree reflects the severity of the defendant's disregard for another's safety. When determining guilt today, as jurors, you must understand some important instructions that will allow you to better perform your duties and uphold values set forth in our legal system and the Constitution. The first instruction is that the charge of any offense is not evidence, and it creates no interference that any offense was committed or that the defendant is guilty of an offense. The defendant is presumed to be innocent until, during your deliberation upon your verdict, you find her guilty. This presumption of innocence places upon the state the burden of proving beyond a reasonable doubt that the defendant is guilty. A reasonable doubt is doubt based upon reason and common sense after careful and impartial consideration of all the evidence in the case. We must remind you that proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. The law does not require proof that overcomes every possible doubt, however. If, after your consideration of all the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you will find her guilty. If you are not so convinced, you must give her the benefit of the doubt and find her not guilty. We must also remind you of the verdict instructions that you were just read about how to determine assault in the second degree by defining what recklessly, which is as to causing serious physical injury, is, and what the definition of serious physical injury is. Please keep those in mind as you make your decision in today's case. The evidence does not lie. She is guilty. The defendant was the driver on that car on October 23rd, 2013. She even says that she was in the car. As my partner Parker got up here and told you, you would hear evidence that proved beyond a reasonable doubt that the defendant is guilty of assault in the second degree. You heard that evidence. The injury on her forehead matches the injury one would expect from a head hitting the front windshield. You saw this in the pictures of the injuries on Betty Quick's forehead, and you saw this in the pictures of the car and the damage to the windshield and in the crime scene diagram. The blood and hair from the windshield damage spot matches that of Betty Quick, the defendant. You saw the lab reports. You know it's true. She was behind the wheel. She was driving. And when the car hit the telephone pole, her head hit the windshield. Mr. Smith's positive identification of the defendant as the driver, Mr. Sharp's positive identification of the defendant as the driver of the car serves to cement the truth that the defendant is the one at fault. There is no escape in this.
As you continue to point out, basically, they cannot prove that this reckless driving was actually by Betty. She continued to state that she was not the driver of the car. And they also seem to believe that somehow, if she was the driver, she somehow only got injuries on her forehead. She didn't sustain any injuries on the left side of her body, even though she was on the left side of the car, and the impact happened on the left side of the vehicle. So I don't see how it was physically possible for her to not get injuries on the left side of her body. Now, according to John Ryder, he stated that he had injuries all along the left side of his body. Now, this must prove that this must show that there's no possible way for John to have been the passenger in that car if he sustained these injuries.